The Fifth Amendment to the United States Constitution gives individuals involved in federal proceedings a privilege against self-incrimination. This means that they can refuse to answer questions or say anything that might connect them to a crime or put them at risk of criminal prosecution. But does the 14th Amendment's Due Process Clause extend this privilege to individuals in state proceedings? The United States Supreme Court faced this question in Malloy v. Hogan. In the late 1950s, police arrested William Malloy during a gambling raid in Hartford, Connecticut. Malloy pleaded guilty to a gambling misdemeanor and was placed on probation for 2 years. While on probation, Malloy was ordered to testify in front of a referee who'd been appointed by a state trial court to investigate gambling and other criminal goings-on in Hartford County. The referee asked Malloy various questions about the circumstances of his arrest and conviction. Malloy refused to answer any of the questions because he was worried that he might incriminate himself. The trial court held Malloy in contempt and sent him to jail until he was ready to answer the referee's questions. Malloy applied for a writ of habeas corpus, naming Hartford County Sheriff Patrick Hogan and seeking a determination that his imprisonment was unlawful. The trial court denied the writ, and the Connecticut Supreme Court of Errors affirmed, reasoning that there was no Fifth Amendment privilege against self-incrimination for Malloy to invoke in a state proceeding. Malloy appealed to the United States Supreme Court, which agreed to take the case.